Okay, everybody. Good afternoon, everybody. We're going to get started. I know you guys have been here for the whole day, and you guys are ready to finish it out. So I'll do my best to hold your attention. My name is Lauren Olson. I am a partner at the law firm of Lewin Pierce, and we are an elder law firm. Just a little bit of background about me. I grew up here in the Dallas-Fort Worth area and had a whole wonderful slew of Catholic education. I went to St. Mark's in Plano, not the all-boys school, the co-ed one. And then I did, as Anna said, went to Ursuline after that. And then after Ursuline, I went to St. Louis University. Yes, we have any Billikens in the room? Maybe? Yeah? Woo! Jesuit school in St. Louis. And then after that, I did step slightly outside the bounds of Catholic education and went to SMU. So had some experience with the Methodists over there for law school. But like I said, so now I'm an attorney, and I just wanted to, first of all, thank the Catholic Foundation for putting on such an incredible event today. You know, I'm excited to be here with you all because I enjoy what I do, and I love sharing that with others. Because when it comes to ensuring that your wishes are followed, information and education is really key. So it's conferences like this, conversations that we're having today that are really crucial for that. So, like I said, I am an elder law attorney, and your first question may be, well, what's an elder law attorney, right? Like, I've heard of estate planning, but I've not heard of elder law, or maybe you've heard of elder law, but only from Better Call Saul, the Netflix series, which is not exactly what we do, right? A little bit different. But as elder law attorneys, we focus on a type of client rather than just one area of the law. So the type of client that we focus on includes older adults and their family members, and then all of the different issues, all of the different legal issues and areas that may affect them. So that certainly includes estate planning, with a little bit of bent towards incapacity and long-term care planning, as well as public benefits planning, Medicaid benefits, veterans benefits, and then we're also in the courts, so we do both contested and uncontested guardianships and probate proceedings. So, as elder law attorneys, when we're working with clients and building long-term care plans, kind of creating like a roadmap for this aging process, we have some goals that we always want to keep in mind. So generally, we're trying to maximize our quality of life for our clients, and we're trying to ensure that our clients' wishes are followed and carried out in both the event of incapacity as well as death. Which is really what we're going to be focusing on most of the presentation for today. And then in addition to that, we also make sure, and we're working to make sure that our clients are protected from exploitation, because the elder abuse and exploitation out there is rampant. It is very scary. I could tell you some war stories all day long. And then lastly, we want to make sure that you have enough assets. We're looking at putting together a long-term care plan to make sure that you have money to pay for your care. So today, as I mentioned, our roadmap is that we're going to focus on making sure that your wishes are followed, okay? And most importantly, first, during your lifetime. We're going to break this down into kind of 3 categories. So the first category or step is talking about critical documents that you have to have in place to make sure that your wishes are carried out during your lifetime. In addition to that, we're going to talk about what documents you need to make sure your wishes are carried out upon your passing. Of course, you've all heard of wills and trusts, and then we're also going to touch a little bit on designation, appointment of agent for the disposition of your remains. And I think you heard a little bit about that this morning too. And then if we can have a little bit of extra time, we're going to touch on paying for long-term care, what that looks like in Texas. Okay, so that is our roadmap. Now, the most important thing that you can do to make sure that your wishes are carried out is to make sure that you have updated and sufficient legal documents in place. Now, a lot of times people ask me, well, can't I just pull this off of LegalZoom? can I just download this from the internet? And I always say, yes, you can. Can you? Yes. Should you? No. This is not the time to cut corners, right? Cut corners on your lattes or wherever that may be, but not your legal documents, okay? Because if your LegalZoom will or your LegalZoom power of attorney, you may think that's good, but you won't know until it's too late if it's not, okay? So this is the time that we want to invest, and we want to make sure that you're meeting with an attorney to make sure that those documents are sufficient. And when you're meeting with an attorney, I just want to always kind of tell people, sometimes it can be intimidating, right? We try not to be intimidating, but when you're working with an attorney, prepare for that meeting. That's a really important meeting that you're having. So bring any existing legal documents that you may have. We always want to look over those. And then in addition to that, make sure that you're bringing all of your financial information, so bank statements, and that's going to help us show how those accounts are titled, who can act on those accounts, what beneficiaries are designated. Anna and Dorina talked a little bit about that. That's really key when we're looking at our overall plan. And then in addition to that, we also want to have some information about your health insurance, right? So you got Medicare. In addition to that, do you have a Medicare supplement? Are you on an Advantage plan? All of that's really important for us to know when we're building a long-term care plan. And then in addition to that, of course, you also bringing any military discharge paperwork. So for any veterans and surviving spouses, we want to look at any possible benefits that you may be entitled to. All right, so now step one, okay, is making sure that your wishes are followed during your lifetime. These 5 documents here are the most important 5 critical documents that every person in this room, whether you're 27 or 77, needs to have in place, okay? And then we're also going to touch on the will and the trust as well. So we're going to go through these. Now the first one is the statutory durable power of attorney, okay? So this one is really critical. This is a document where you are naming someone who you trust to step into your shoes to make financial and legal decisions for you, okay? Now, the statutory form for this document changed pretty significantly in 2017. Our legislature meets every 2 years. Well, now we got a lot of special sessions, but generally speaking, every 2 years, and they like to tinker with things. So it's always good to just check up on your documents, right, and to see how those are doing. But generally speaking, there's a couple of key provisions that I want all of you, when you go home, you're going to pull out your durable power of attorney, and I want you to check on some of these things, okay? So the first one is going to be your agent, right? In the document, you're designating someone that you trust. And of course, you should have you've got a primary agent, the first person that you're naming, okay? And then you have to have alternates in place. It's really critical to make sure that we have contingencies, right? People that can step in the event that your primary agent passes before you or becomes incapacitated or just can't do that. Now, a lot of times my clients will say, well, my husband and I were married, and both of our names are on our accounts, and both of our names are on the deed to our house, so we don't even really need this document, do you? You do. You must have that. Even though it's just kind of a general myth out there, even though you are married, if you are married, that doesn't give your spouse the legal authority to make all of your decisions for you. Yes, maybe your husband or your wife can make withdrawals out of your checking account if it's a jointly owned account, but just because husband and wife are named on the deed in Texas for your house doesn't mean that he or she can sign on your behalf. Okay, so this is really important to make sure that even for your spousal situation that you've got a good, strong, durable power of attorney in place, okay? In addition to that, we see a lot of my clients now are having, kind of generating more and more wealth in individual retirement accounts, your IRAs, your 401ks. Those are titled in your individual name. In order for your spouse or your children to have any authority over those documents, you're to make distributions out of that, investment decisions on that, you have to have this document in place if you are not able to do that. So another question that I often get is, well, we have 3 children, right? Bonnie, Betty, Susie, and Johnny, and they get along swimmingly. They always do, and always will, forever and ever, right? And as you are all laughing, that is not the case, right? So everybody says, well, I just want to name them all 3. I don't want to decide. I love all 3 of them, okay? And we'll name them all as co-agents. I really, really recommend that you do not do that, right? It's really important to have one person for these financial decisions and for medical decisions, which we'll get to in a minute, to sign the dotted line and ultimately make that decision. Because I'd say about 75% of the litigation, the contests, the fighting that we do in our office comes from co-agents, co-executors, co-trustees, okay? So that's really important. I'm not saying that you can't do it, but it's really critical just to evaluate your situation to decide if that's really best for you guys. Okay, so we talked about who you're naming, and then there's also a section in this document, it's gonna be probably around page 2 or 3 when you're looking at your documents, that talks about when this power of attorney becomes effective. Okay, and it's gonna be a bold language, and it's gonna be either option A or option B. And the first one is that it is either effective immediately upon signing that document, or only effective upon your disability or your incapacity. That second option is what we call a springing power of attorney, meaning it only springs into effect once you've been determined totally incapacitated by a doctor. And that oftentimes is difficult. We need these documents in more emergent situations. And if we're having to call doctors and get them to put, well, first of all, get a hold of them, right? Second of all, for them to put, that's a big statement, right? For somebody to say that you're totally incapacitated before your loved ones, the people that you trust, can make any decisions for you. So that's really critical to look at when you're looking at your documents and when it becomes effective. Generally speaking, location you see here on the slide, there was a case and new law that came into effect a couple of years ago that talks about the power of attorney. If your agent is using that document to sell real property, the title company will look and see, and it needs to be signed in an attorney's office or in the office of a title company. And they are starting to really enforce that. So this is just another reason why pulling something off LegalZoom and signing it on your kitchen table may not be what's best for you in the future. And then last but not least here, we talked about capacity. This is a great question that we get a lot, right? Is what capacity, what do you have to have in order to sign these documents? For the powers of attorney, it is contractual capacity. And so generally speaking, that just means you need to understand the nature of the transaction, right? That you're contracting to give these powers to this person, okay? And so if you or your loved one or anybody in your family has received a diagnosis of dementia or other cognitive decline, that doesn't mean that you can no longer sign documents, he or she, right? That's oftentimes actually the best time, if it's early on enough, to reevaluate your documents and make sure that they really are in true good form, okay? Now, quickly here, so we talked about who you're naming, what capacity you have to have, and then a huge portion of this document is about what powers you're conveying to your agent. Now, we have the standard statutory form powers, okay? So this is your standard stuff. This means you're giving your agent the ability to handle your bank accounts, sell your house, deal with your retirement accounts, taxes, all of those really fun things, right? But in addition to that standard list, as elder law attorneys, when we're thinking about long-term care planning, we want to include some expanded powers in this document that are more specific to your situation. So that would include setting up and funding any particular trusts. That might be for Medicaid, for example, We want to make sure that your agent can contract with caregivers, right? Bring caregivers into your home, help you qualify for public benefits, and generally speaking, just help you plan for long-term care. So that's what we want to look at when we're looking at these powers, okay? Okay, so I could talk for days on the durable power of attorney alone, all right? But in addition to that, what's also really important is your medical power of attorney, okay? So in similar fashion, medical power of attorney, naming someone who you trust to step in and make medical decisions for you. So that includes authorizing procedures, dealing with medications, communicating and working with these medical professionals. Now, a difference between the medical power of attorney versus the durable power of attorney is that by operation of law, your medical power of attorney only becomes effective once you're determined incapacitated, which that just generally makes sense, right? The doctor's always going to turn to you first to make your own decisions, and if he or she feels like not getting good direction from you, then will they turn to the agent under the medical power of attorney. In addition, it's just important to know that the medical power of attorney does not give your agent the ability to force you to move somewhere against your will. Right? Only a guardian can do that. So an example would be if you have dementia, Alzheimer's, another form of dementia, and you're living at home and you're hoarding and you're not taking care of yourself, right? A medical power of attorney can't necessarily force you into memory care against your will. Right? That might be an example of when we would need to seek guardianship beyond just your powers of attorney. And the other thing is that medical powers of attorney can't prevent family members from seeing you, right? Oftentimes that happens in some fights, waving around the medical power of attorney to their sister saying, you can't see mom, right? I'm the medical power of attorney. No, 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 that's not how that works. So medical powers of attorney, in general, these are somewhat restricted or limited statutory forms, right? You're naming an agent to make some medical decisions for you. But long-term care planning, end-of-life decisions are not simple, right? Those are pretty complex. And as Catholics, we strive to embody and carry out our Catholic moral principles and teachings. And one way in which we can do that is within our medical decision making. And so I'm really grateful to the Bishop's End of Life Project because the bishop worked with the St. Thomas More Society, which is a guild of Catholic lawyers in the area, as well as doctors and bioethicists, to come together to put together some forms that include Catholic principles in the medical power of attorney, as well as the advanced directives or the living wills. So I have the link here that you see on the slide to these forms, and I also have some handouts where I've kind of extracted some of the principles or provisions that this project has incorporated into the Catholic medical power of attorney, as well as the Catholic advanced directives. So if we kind of touch on those, in the Catholic medical power of attorney, there are some provisions in there that basically say at the beginning of the standard statutory form, it just kind of advises your agents to remember, right, that you're Catholic and that you want them to carry out your decisions in accordance with your Catholic moral beliefs and teachings. And it also points then to the Catholic advanced directive. So again, I have some key provisions in a handout for you all that you can take as well. So that's the medical power of attorney. Separate from that is an advanced directive, or what we call a directive to physicians, all right? And a directive to physicians is commonly called your living will. You all may have heard of that term, living will, all right? This is not your DNR. DNR is the do not resuscitate form. DNR talks about cardiac resuscitation, right? That's something you do with your doctor, whereas the living will or your directive is a document that you would do with your attorney. And the directive provides instruction to your medical power of attorney, your agent, about end-of-life decisions. So generally speaking, in the event of a terminal or an irreversible condition, then your options are that you would either wish to discontinue life-sustaining treatment, but be kept comfortable with hospice care and other palliative measures. Or option B says no, that you want that life-sustaining treatment, those machines, to keep your organs going in that situation. Now that's very, again, kind of restricted, right? Very black and white, A and B, right? And again, making these decisions and long-term care and end-of-life decisions, there's a lot of gray out there. And this is where the Bishop's End-of-Life Project has also helped us, because they've created an advanced directive that provides, again, some more general directives into this document, okay? And I have a list of those for you in that handout, but just generally speaking, it provides some instruction on what life-sustaining treatment means, and the biggest principle is about when to continue or to withdraw life-sustaining treatment and artificial nutrition and hydration. That's a big one. That's a little bit different as Catholics than the general statutory definition, which is pretty broad. So these are key, and this is something that I have for you and what you really want to look at for your documents as Catholics. So we already talked about this is the directive to physicians, so we're going to kind of keep going through that. The next one is your HIPAA. You all know the HIPAA, right? The HIPAA is just a document where you are saying these people can access my medical information, okay? So they can communicate with the doctors and medical professionals. There's no particular order of people on this, no hierarchy. Everybody who listed on this document can access medical records and talk to the doctors about how you're doing. Now, this one, again, is really important just to kind of incorporate with your medical power of attorney. Make sure that everybody listed on the medical power of attorney is also listed on the HIPAA so that your agents can get good information to make good decisions for you. And this is just a global HIPAA. You sign, I'm sure, a new HIPAA every time you go to the doctor, right? Your primary care doctor, your cardiologist, you name it. You got a lot of HIPAAs out there. Okay, so this is just a general one that should you go, for example, have an accident and you're in the emergency room, this kind of covers all of your bases. And now I tell my clients, there's a lot of electronic portals, right? So whether you're with the Baylor system or UT Southwestern, uploading your medical documents, your power of attorney, your HIPAA, your directive, there's a section on those portals where you can upload those electronic documents, and then everybody can access that no matter where you are. So that's just another good way of storing things electronically. Okay, so next up is the Declaration of Guardian, okay? So this is a document that says if you ever needed a guardian in the future, this is who you would want the court to appoint for you. Now, you all may be thinking guardian, well, you named guardians perhaps for your minor children way back in the day, but this is different. This is for yourself. If you become incapacitated and can't make decisions for you, right, this is a document that says who you would want the court to appoint. Now, hopefully a guardianship is never necessary, because if you have the durable power of attorney, the medical power of attorney in place, that's going to take over for you to help make those decisions. But sometimes those powers of attorney are not strong enough or effective enough for key situations. And as I alluded to at the beginning, as elder law attorneys, we see a lot of exploitation out there, both within families and outside of families. And sometimes the durable power of attorney, the agent, those scammers are so professional, right? And so on top of everything that it's hard to keep up with them. And sometimes we have to go get a guardianship in place despite having a durable power of attorney. And again, I could tell you a lot of war stories about people wiring $500 million overseas, and to who they believe are the IRS, or gift card scams. It's out there, it happens, and it's very scary. So that's why we always just want to be alert. Even though you have documents, check in with your family members. Talk to them about that, right? How are they doing? Look at the accounts. Make sure that everything is still all on the up and up. So those are all the documents during your lifetime. All right, so that's step one, which is a big step. Step two, or category two, is ensuring that your wishes are followed upon your passing. And that really boils down to the will and the trust documents. In addition to that, one that I don't have on here is another document about appointing an agent for the disposition of your remains. That one's also key. This says it names somebody to work with a funeral home to carry out your wishes. Do you want to be cremated? Do you want to be buried? Sprinkled somewhere special? Whatever your wishes are, that's what you can put in that other document. Okay, so that's also really key. So first, we're going to talk about the will, and then we'll touch on the trust. But a lot of times people ask, well, do I need a trust, right? What's the difference, and why is a trust better or not better than the will? And I always say the classic lawyer answer is, it depends, right? Depends on your situation. So first we'll talk about a will. You all know this one, right? Your will is just a document that says you're designating, who you want to receive your property upon your passing. Okay? In addition to that, though, you are also naming and appointing an executor. The executor is the person who is in charge of, collecting the assets, paying off any debt, and then distributing those assets to your beneficiaries upon your passing. Okay? So that's a big role, an important role to have. This is really key, of course, to have a will to make sure your wishes are in writing if you have a blended family. And the reason being is that if you don't have a will, okay, the laws of intestacy is what we call that in Texas. The state of Texas has essentially written a will for you, right? So if you die without a will, that doesn't mean all of your money goes to the state of Texas or anything. It says that it's going to pass according to state law. And if you're in a blended family situation, roughly, it's a split would be 1/3 to your surviving spouse, 2/3 to your children from a prior marriage. So if that's not consistent with what you would want, got to make sure to get that in writing. We got to have a will in place to take care of those scenarios. Capacity, the capacity to sign a will is a little bit different, actually lower, than the capacity to sign a power of attorney. And this is called testamentary capacity. And generally speaking, you got to know what assets you have out there, and you have to know the nature of your bounty, kind of a fun legal term, which basically just means your family members. Okay, so that's the capacity that you need to have to sign a will. You can sign a will on one day and totally forget you signed the will the next day and it still be valid. Capacity, testamentary capacity, is in the moment. Okay, so that's key when we're looking at signing documents in situations of dementia and other things like that. Also, the will itself doesn't do anything until it's admitted to probate. Right? A lot of times people will run around saying, oh, I'm the executor, right? I'm Dad's executor and he gave me all the power. It's like, well, you're not anything until a judge appoints you as the executor. Okay, so you have to go through the probate process in order for the will, to be valid. And you don't always have to go to probate. It depends on how the assets are titled. Okay, and kind of get into that. Generally speaking, if you have beneficiaries designated on accounts, that's what I would call non-probate assets. They pass directly to those designated beneficiaries. And if there's assets, though, in your individual name, then those are probate assets that typically have to go through that process, that probate process, and pass pursuant to your will in order to convey or transfer title to those assets. Okay. So we talked about the will. And also included in the will, some key things to look at when we're looking at long-term care is also some possible contingent trusts in your will. So of course you want to include in there if you have minor children or grandchildren, and you and your spouse pass and it goes to any minors, then you want to make sure that that passes in a trust for those minors until they turn a certain age. And you can designate that age, right? 18 legally is when they can inherit. 21, they say male brains don't fully develop until 25, so maybe 25, but you can choose, right? But in addition to the minor contingent trusts are also special needs trusts. And I will tell you that I include a contingent supplemental needs trust or special needs trust in all of my wills. In the event that a beneficiary in the future, right, upon your passing is incapacitated and may need long-term care or public benefits, then we want to make sure that that beneficiary's share is routed to a contingent special needs trust to protect those assets if they are not able to fully handle them and not knock them off any benefits, whether that's Medicaid or any other public benefits. So we've got to look at that if we have any diagnoses and any cognitive impairment. And we talked about intestacy. Okay, so after the will, of course, you've all probably heard about these trusts, right? And there's a lot of different forms of trusts out there, but the most common one is what we would call a revocable living trust, all right? And a lot of times people come to me and they say, well, I have this trust, and I say, that's fantastic, that's great, what's in the trust? And they say, oh, what do you mean what's in the trust? There's, it's leather bounded, it's about, 500 pages long. And I say, that's great, and you got it at a fancy steak dinner, right? You got a steak for free along with that trust document. But what's key is titling the assets into the trust, right? Having a revocable living trust does avoid the probate process, but it requires some maintenance and some administration during your lifetime, right? Any assets that you acquire, you got to make sure to convey those into the trust in order for it to be effective, both during your lifetime and then once you pass away. So it, again, names your beneficiaries upon your passing. It designates trustees to manage those properties during your lifetime. And in Texas, our probate process here, so what we call an independent administration. It's relatively straightforward, especially in Collin County. This is the good place to be. Easy probate proceeding. You go to court once and you never have to go back, generally, unless there's problems, okay? So avoiding probate, having a trust just to avoid probate, that alone is probably not the best reason just to do it. There can be benefits, though, to a revocable living trust, and that is if you have property in another state, right? If you have a lake house or a cabin in Oklahoma or Colorado, it can be beneficial to have a trust so that you're not going through that probate process in two different states. The other thing is that if there are some feuds, fights between the family, sometimes having a trust can prevent going to court, going through that probate process to help forestall any issues there. And then also it can help with some incapacity planning in the future. But what's really key here, and again, we do a lot of public benefits planning, is that revocable living trusts don't always mesh well with public benefits. And the reason being is that if your house, your homestead, is titled in the name of the trust, it is a countable asset for Medicaid purposes. If it is in your individual name, then it's exempt. It does not count if you needed Medicaid in the future, okay? So that's just something to think about. Medicaid is an asset-based benefit, looking at your income and your assets, and that's huge, right? Your house is a key, big asset, so we want to make sure, while you may not need Medicaid now, if you did in the future, let's preserve that possibility by making sure that your house is titled in your individual name, not in the name of the trust. Okay, so now if we want to just briefly touch on, we've got a little bit of time left here, is paying for long-term care. okay? And this is also really important to make sure that your wishes are carried out, not just financially, but medical decisions, and what kind of long-term care, what you see for the future for yourselves. So in order to make those decisions, you gotta have some information and some education about that. So in Texas, paying for long-term care, well, first of all, does not include Medicare, right? You all probably know your Medicare does not pay for long-term care. At most, your Medicare is gonna get you up to 100 days of rehab in a skilled nursing setting, okay? And if you have a supplement, it's gonna cover the remaining amount of those 100 days. But after 100 days or sooner, Medicare stops. And then we are looking at three main options. And the first one being private pay, okay? We're in a relatively affordable part of the country, everybody, okay? But long-term care is still very expensive, right? And it can, at these rates, from anywhere, you know, $4,000 in a residential care home up to $12,000 in memory care, $18,000, $20,000 a month for at-home care, 24/7 care at home, that's gonna clip through anybody's assets rather rapidly. So we all need to be thinking about this, okay? And private pay can't last forever. In addition to that, long-term care insurance, that's huge. If you have it, great. If you don't and you're still able to get it, think about it. It's really, really important, and it can be a great, you know, kind of gap filler, right, between when you need to start dipping into the principal of your assets to pay for long-term care. So we've got private pay, long-term care insurance, and then last but not least, we have public benefits. Just so that everybody knows, in Texas, that really amounts to either veterans benefits or Medicaid, okay? And both of these benefits are needs-based benefits, and that they're gonna look at your income as well as your assets when qualifying for them. So first, we'll just touch on very briefly, Medicaid. There's a million different Medicaid programs out there in Texas, right? We've got CHIP, we got Children's Medicaid and Medicaid for pregnant women. What we're talking about today, though, is Medicaid for long-term care, okay? And so for the most part in Texas, Medicaid really only pays for skilled nursing, okay? Now, there's a sliver, very small program out there that pays for some assisted living and some home care, but for the most part, we're really looking at a nursing home or skilled nursing. And if you have dementia, right, or other cognitive impairment, you're more likely to need memory care, which in Texas is licensed as assisted living, not skilled nursing, okay? So that's just a little bit of a gap in our system there. But Medicaid, like I was saying, in order to qualify for that, they're gonna look at your income as well as your assets, okay? And so for the income, we have an income cap this year for the person who needs benefits, okay? Their income, your gross monthly income, needs to be under $2,742. So just a very random number, I think, just to make sure elder law attorneys can stay up on our toes, right, and memorize numbers. But generally speaking, $2,700, that's if your income is above that, then that doesn't mean you'll never qualify for Medicaid. What it means is that we need to get in place what's called a Miller Trust or a qualified income trust. Point being, I know this is kind of a lot for today, is that what we can do now, even though you don't need Medicaid now, is that let's make sure that in that durable power of attorney document that we were talking about at the very beginning, that we are incorporating provisions to account for these situations in that document now, right? Make it specific so that in the future your agent can account for these issues if they were to come up. And then of course there's an asset limitation, right? So for a single individual in Texas to qualify for Medicaid, your assets have to be below $2,000. That's crazy low, right? That's very low. And for a married couple, though, it's a range, okay? And it's a complicated equation, but generally the high end of that range is $150,000, well, this year, $148,000. But that is for countable assets. So there are assets that count, and there are assets that are exempt, okay? So we just need to know the house is an exempt asset. That's huge, right? That doesn't count towards that $148,000 or $2,000 asset limitation. In addition, a couple of years ago, Medicaid, or Health and Human Services, also said that qualified retirement accounts, IRAs, are an exempt asset for Medicaid. Interesting. If the principal is receiving his or her required minimum distributions off of that. That's telling me I'm running close on time. So, point being is that there are ways in which it's possible to qualify for Medicaid and some of these public benefits, and that's where you just want to really look at, talk to an attorney, an elder law attorney, and then make sure that your documents are effective now, right, that they have key provisions now to account for some of these situations in the future. And last but not least, there are also veterans benefits. So for any veterans here in the room or his or her surviving spouses, there is what's called a non-service connected disability pension. It acts like a pension benefit for veterans who need long-term care. Okay? And that is if you served 90 days of continuous service and 1 day of wartime period and a non-dishonorable discharge. Okay? The VA is going to look at your income and your assets as a whole. They're going to look at a married couple's gross monthly income, and they're going to see what medical expenses you're incurring. And if your medical expenses are surpassing your income, then that's going to mean that you're going to qualify for the benefit. If your assets are under, this year it's $150,000, okay? But again, your house is exempt, and that's something that we want to analyze on an individual basis, okay? So I just wanted you all to know about some benefits and paying for long-term care, but I'm also going to stop there and turn it over for any questions that anybody may have. I know that was a lot of information that I just threw at you, all right? So anybody have thoughts or questions?
Okay, we've got right here.
I have a question. My will was written in Florida. I tried to ask here if it was still effective. I essentially didn't get an answer, but only kind of I'd be better to do it here. Who knows, because I'll be buried in Virginia. Mm-hmm. It was written in Florida.
States,
so
right?
where do I go? Just write one for all of them?
Right, that's a fantastic question. And so in Texas, let's say if you pass away here in Texas because you have to probate in the county in which you're residing in at the time. So in Texas, we have a statute that says if you signed a will in Florida, then we're going to rubber stamp it. We're going to say that it's valid here if it met all of the requirements under Florida law at the time, okay? So for that reason, I would say that there's just a little bit of an extra step that the attorney at the end might have to go through to analyze that. Generally speaking, yes, there's a way in which it can be effective, but it's always good just to check up on that. Right, not necessarily. We have a law in Texas that says we're going to accept or, take into account wills and other documents from other states. But that's a great segue to say that your powers of attorney, all of these documents are state-based documents. That doesn't mean that they're not going to work, right, for assets in other places or if you were to move. It's just all about the third-party entities that we're up against, the banks, the title companies of the world. So that's why it's just good to double-check and make sure that it's sufficient in whatever state you end up moving to. Yeah, oh, sorry, I'm not, any?
What's the advantages
Yeah.
of an irrevocable trust over a revocable trust?
Yeah, so good question. So an irrevocable trust is something where you would essentially be taking all of your assets and transferring them into an irrevocable trust, okay, for you and your heirs to ultimately manage. I will say that the disadvantage of that is what is a transfer. So if we were looking at public benefits in the future, Medicaid as well as veterans benefits has what we call a look-back period. And I didn't touch on this, but for Medicaid it's 5 years. For VA it's 3 years. So if you're transferring all of your assets entirely out of your name to an irrevocable trust, that's a transfer. That would be a penalty and might prevent you from qualifying for benefits in the future. And it also has certain tax implications, and it's essentially, it's not flexible, an irrevocable trust. So you gotta be really, really careful before looking at that, and everybody's situation is different though. Yeah.
Here's one.
Or, oh, okay,
Just a quick question. You were talking about all those being state-based.
right.
With children being all over, and you've got your power of attorney with the child out of state, how does that affect
Right.
you and the state attorney?
Yeah, it is possible, right? So your children are, you know, global right now, all over the world working on that. So it's fine to have your agents in other states for, especially on the financial side of things, right? Now we can do everything online and communicate from wherever we are in the world. I do generally advise my clients, though, that for medical decision making, it can be beneficial to have somebody local. And so that's just something to think about. It's not mandatory, but it might be an important part of that discussion when you're trying to decide who to appoint. Who's going to be there with you when you really need them at the doctor's office, right? Boots on the ground. Okay, so it's just something to consider.
Hey, Lauren.
Yeah.
Great information. One of the things you mentioned that I'll just kind of piggyback on.
Please, please.
Is a lot of people think that power of attorney, durable power of attorney, is forever.
Yeah.
And it ends at the time of death.
Right.
And so when we get those families that are really getting along, like you mentioned earlier,
Yeah.
and we have one of them come in and say, well, I have mom's durable power of attorney, I can do everything. A lot of people, it's a misconception that it's not correct. You mentioned the appointment of an agent and right to control disposition. Those are very important documents.
Exactly. Yeah, and that's a good point, is that your powers of attorney, that step one, that first category that I was talking about, all of those documents cease upon your passing. So the agent under your durable and your medical power of attorney, they don't have the authority to make decisions for you upon your passing, right? So, and other times people are trying to do it. They're running around with that document even though you're deceased, right? But that's when it transitions over into your executor and your trustees under those additional documents.
But didn't you say the executor can't be appointed until it goes through probate?
That's right.
So
Yep.
that
So
can
sometimes
be-
there's a gap, right?
Right.
There's a gap in there about authority, about who has the authority to make decisions for you. And that can be an advantage of having the trust, because that trustee has continual authority. However, if you have set up your assets with beneficiaries designated on them, right, then there is no need for the executor to be appointed, and they work with the financial entities to carry that out, the disposition of those assets.
One more question?
Yeah.
Yes, I have a sister who lives in Colorado.
Okay.
She's in a memory care unit.
Okay.
Her daughter passed away.
Oh, which is a great example, right, of caregivers sometimes passing first.
Right.
Yeah.
Then her son-in-law didn't want to be responsible,
Okay.
so her grandson didn't want to be responsible.
Oh,
So it came back to me as her brother.
yeah, yeah.
And I have no, Social Security has given me authority to set up her account.
Sure, as representative payee for Social
Yes,
Security.
But where do I stand then with the power of attorney of anything else over her?
Yeah, so first of all, you would look and see if she has documents in place, were you listed as an alternate in any way there, right?
No,
And if
I'm
not, then in Texas, and I don't know about in Colorado, I'm only licensed here in Texas, but in Texas we have default provisions that say if there is not a medical power of attorney or your agents can't act for you, then it would default to your spouse or your adult children, right? And then, only then would it go out to your siblings. So if the adult child is there but is refusing to act, then that might be something where you're really looking at if your sister can no longer sign documents. That's an example of when a guardianship might be necessary. Of course, kind of depending on the situation.
Okay, thank you.
Yeah, you're welcome.
Okay, any last burning questions? Okay.
And I will also be hanging around too, and so I've got cards and information, so if anybody has any other questions, I would be happy to chat.
Thank you so much.
Yeah, you're so welcome.